looking at this case right now, there are currently 94 lawsuits against the mandate in some 23 states. Jami Floyd is our legal contributor here at Al Jazeera America. And Jami, there are fears that this case might open the door to any commercial enterprise saying they want to be exempted from the Affordable Care Act.
That's exactly right, because here they're looking for an exemption on religious grounds based on the contraception issue. But you could say, I don't want to have employees who immunize their children. I don't want to have employees who seek psychiatric care. There are all kinds of religious exceptions you could take. And so if the Supreme Court were to find for Hobby Lobby, you could see small companies or large corporations claiming some sort of religious exception based on this case, depending on how the Supreme Court comes down.
But as in all cases before the court, there are two sides. Why is the Religious Freedom Act so important in the arguments before the court on this case?
Well, the Religious Freedom Act was passed in 1993, signed by President Clinton. It was overwhelmingly popular, and it was there to reinforce the principles of the First Amendment. It's a federal law, but 18 states have passed their own religious freedom acts, and it is part and parcel of what the court will be looking at. What they're going to be arguing today, it is a case about religious freedom versus women's rights. Should a company, and this is Hobby Lobby's a big company, we're talking about 600 stores in 41
about
states.
15,000 employees.
15,000, and some say as many as 22,000 if you count part-time employees. So we're talking about a major company. Should they be able to impose their will or their desire or their religious preferences on the employees who have their own desires, wills, and needs as employees? So that's women's rights versus religious freedom.
But some say this issue has already been decided. The court has already ruled that corporations and campaign finance laws are individuals. So why does that protection not affect their religious beliefs?
Well, there are two precedents here. There's the big old Citizens United case. Remember that? And that's where the Supreme Court said that for political campaigns, corporations are people. They have First Amendment rights, but in the political context. This is now, will corporations have First Amendment rights in the religious context? Do they have religious freedoms? Now this other issue, the other precedent will be the Affordable Act case. That was a very closely decided case. That came down to one vote, and that vote, of course, was the Chief Justice. So this case, I think, will be very closely decided as well. The Affordable Care Act case was very closely decided, and I think this will be very closely decided.
Jami, I have to ask the question, is this really, though, about the religious freedom of Hobby Lobby, or is it about Obamacare that we've now seen Congress try to do away with 50 times?
I think it's about a lot of things. I think there is a political campaign against Obamacare. This is looking at one slice of Obamacare, that contraception slice. So I think it's about Obamacare, the continued attacks on the Affordable Care Act, which people like to call Obamacare. But there's also the attacks on women's freedom and contraception, which a lot of people would say should have been established 40 years ago with Roe v. Wade. But we're seeing a rollback of attacks on women's rights. We're seeing a rollback on that. There are abortion legislations going on in a lot of states around the country, and the attack here on contraception. Now, the Hobby Lobby people would tell you that they're not opposed to all of the contraception provisions in the Affordable Care Act. They're only opposed to 4 that look a lot like abortion. But they are providing in the Affordable Care Act for 20 others that they will accept. And they simply don't want to provide for those 4. But Hobby Lobby is being financed by a very powerful anti-choice religious group.
The courts always say that they are neutral on these issues. But if we learned anything in Bush v. Gore and also Citizens United, it is that the court makes controversial decisions, and they are criticized in the political arena. Do you expect politics to play a huge role in this?
Well, it's interesting. I just recently went to a forum that was chaired by a Yale law professor, NYU law professor, and one of the greatest scholars of Supreme Court, who wrote for the New York Times for 40 years on the Supreme Court. 4 decades she followed the court. And they all agree that the Supreme Court has never been ambivalent about public opinion. They might say they are, but going all the way back to our founding, they are aware of public opinion. They can't help it. We would like to think that the court is not aware of what public opinion is, but they do respond to public opinion, like it or not.
Jami Floyd, our legal contributor here at Al Jazeera America. Jami, thank you very much.
Pleasure to be here, Del.